Welcome to Tea Time with the Jackson Center. I am Kristan McMahon, and I have the pleasure of serving as the president of the Robert H. Jackson Center in Jamestown, New York. Today's guest is St. John's University law professor and the Jackson Center's Elizabeth S. Lenna and board member, John Q. Barrett. John, welcome back.
Thank you, Kristan. Great to see you. Great to be here.
Thank you. Well, so we're dipping into historic times today, since we are in the 75th anniversary cycle for Nuremberg. And we're going to be talking about the time that has elapsed from when the London Agreement and Charter was signed on August 8th to when the indictments are finally presented to the tribunal on October 18th. So let's start at a high level. What has been occupying this time frame?
Right. So we're in 1945, and Robert Jackson had been recruited in April of 1945 by President Truman, unveiled in May, and then spent the summer doing the diplomatic work of organizing the Allied joint project to hold the Nazis, the surviving arch-Nazi prisoners, accountable as criminals. And in August, in the London Agreement, they have created the world's first international criminal court, the International Military Tribunal. And now they have to sort of deliver on it and get ready to prosecute. They do sort of scatter a bit. The Brits obviously are in and around London and are doing their work there. And there are members of the American team that stay in London, and they're assembling evidence and starting to draft an indictment. Robert Jackson does some hopscotching. He flies to Italy. It's a little bit of an R&R junket. It also involves meeting with the Pope and kind of high-level diplomatic work to try and get Vatican evidence to be used in the case against the Nazis. Then he is doing some visits to the continent and back to London, and then ultimately returns to the United States. And so he's in the U.S. for a little bit short of 2 weeks in early September of 1945. And he's consulting with President Truman. He's touching base, but not really doing any work in his day job at the Supreme Court. He's coordinating with his staff, his Washington staff at the Pentagon. He's recruiting a little bit more personnel. He's probably getting his winter suit. And then he gets on the plane on Monday, September 10th, to return to Europe, and pretty quickly is in Nuremberg, which has been selected as the site for the trial, and it's pre-trial preparation.
One of the things we had talked about with the London Agreement and Charter was some of the challenges with reconciling the various legal systems and their approach to and or outlook on the law. And there's a similar challenge with how each of the allies is conceptualizing the trial itself. Britain, for example, I think thought it would be no more than 10 defendants, so it could start quickly and end quickly. I think Jackson and his team were really looking for how broadly can we go with these. And I think, and if I remember this from the London Agreement discussion as well, the French and the Russians sort of always thought, well, this is only the first trial of many. So how are we preparing for those subsequent trials as well? What do you have any insight into some of those machinations or Jackson's thoughts on that?
Yeah, there's a sort of identify the defendants project that's really going on during the summer, July into August, as they're doing the London negotiations. And there are draft lists of prospective defendants. Some of them are frankly based on nothing more than notoriety. Like, these are names of Nazis I've seen in the newspapers, and they appear not to be dead, or they are prisoners. So some of those lists are actually much longer than the ultimate 24. But you know, all the lists begin with the biggest names: Hermann Goering, Rudolf Hess, Joachim von Ribbentrop. The thing that they are all conceptualizing is a numbers problem. That, you know, Nazism is a pyramid, and there was Hitler and there was an inner circle, but there are lots of people who are decision makers and are perpetrators, and not just in localities. They have a sort of spanning responsibility. So they are kind of candidates for an international accountability process. And so the plan going into London and the agreement coming out of London is that the tribunal has jurisdiction over not just individuals, but organizations, and that indicting and convicting organizations will then make it efficient in subsequent trials to prosecute, sort of the leadership of organizations. Once you've established that the SS is a criminal organization, a crime family, if you will, then who are the bosses and the decision makers in the SS? So I think that everyone is thinking that this will not be the only international endeavor, but how many subsequent cases, how much of a focus on individuals apart from membership in organizations, that is all kind of down the road and quite, I think, vague in everyone's mind. It's hard enough, I think, to really get the first one assembled and off the ground.
One of the things you mentioned in there too was the sort of global scope of it. So they weren't really concerned with, or it was of lesser concern of, this person did this thing in Poland. And so that would be that very local. But at this time too, there were also some other countries who were raising their hands and trying to figure out if they could get involved in this legal process. And I think Poland was one, and Czechoslovakia. And there might have been a few others, and that was
in what we call the Nuremberg process.
Yes,
absolutely. They're, yes, the Czechs and the Poles, a number of other nations. They want to prosecute, they want to be on a team, they want a count in the indictment focused on what the Nazis did during their attack on aggression against occupation in that particular nation. So yeah, there's a lot of that to kind of fend off and manage. At the very practical level, remember that we're talking about a 4-language proceeding already: German, English, French, and Russian. And adding another language, much less 4 more languages, is an unimaginably complicated thing. So at that basic level, Robert Jackson is rebuffing some of the national interests in joining this and adding their language, if you will. It's also, frankly, a relief that there's not a suitably senior surviving Italian perpetrator. Thank goodness Mussolini is dead, because otherwise, Mussolini was an arch criminal who certainly deserved to be in the dock, and that would have meant a 5th language. So yeah, there is that sort of jockeying going on. The framework for Nuremberg is arch criminals whose crimes transcend any particular geography. So alongside this international project, one trial and then whatever successor trials, there are locality proceedings in the newly liberated nations, in the sectors that are American, British, Russian, and French. In Norway, they have Quisling on trial because he was the Nazi puppet in the occupation of Norway. So kind of the things that had venue elsewhere were to be handled elsewhere. The things that had no particular venue or spanned at all, that's in the project bucket that becomes Nuremberg.
And that makes sense. And so we're having these machinations trying to figure out who are we listing, what are we listing. My recollection too is, although Jackson very keen on moving forward with the organizations, and certainly that was written into the London Agreement and Charter, the other allies sort of hoped either he'd forget about that, or maybe it would be a very small number that they would be looking at, because in their mind, it seemed to think that that would just overly complicate and certainly slow down, I think, how fast they were hoping to move.
Yes, it is an American concept. It's part of the American War Department plan that Jackson inherits and is kind of implementing. And maybe it kind of descends from American corporate criminal prosecution. And Jackson, of course, had run the antitrust division in the Department of Justice and so forth. It was much less conceptually familiar to the other nations. But it was important in terms of accountability, and also to decapitate the prospect of a Nazi resurgence, to prevent a future Nazi Germany and a World War III, was one of the things that kind of working down the pyramid would theoretically accomplish. I mean, those fears turned out to be very overblown, but as they're sitting there in 1945, they don't really know how many Nazis are in the woods and ready to, come out and rally and so forth. So dealing with the numbers is about the peace of the European continent and all the nations are in support of that.
Nice. Okay. So we're getting towards the end of August, I think, at this point, and the 24 names are about to be published. How was that list received?
I think it was a successful unveiling. There was a little bit of kind of translation and time zone issue, first with the defendants list and then later with the indictment, and trying to sort of stop one nation from jumping the gun, but also making sure that all the typos had been cleaned up and that it was the right list and not a draft that had been superseded. But, I think in the eyes of the world, to the ears of the world, this looked like progress. It looked like appropriate leader figures, many of whom were familiar names. So, by and large, I think it was well received. There were, of course, some, omissions or missing players. And there's, certainly people who are sort of expert and lobbying in the background. I mean, kind of where is Adolf Eichmann is probably the paradigm of this. And the World Jewish Congress, lawyers who are assisting the Jackson team have been saying, since the summer, Eichmann is a huge perpetrator and Eichmann should be on the list of prospective defendants and so forth. But as far as everybody knew, there was no reason to believe otherwise. Eichmann was dead. Unlike Martin Bormann, who was missing, there was concern that he was a fugitive, and so he was indicted and prosecuted in absentia. But Eichmann was really believed to be dead, of course, erroneously. So, that's an example. Another figure who there's some debate about is Otto Olendorf, who becomes the lead defendant in one of the subsequent American trials as a leader of the Einsatzgruppen murder teams. And there was, kind of some debate about Olendorf, but he's really kind of a number two to Goering. And the selection of defendants are sort of lead perpetrator sector by sector and not sort of doubling up. So, kind of one Wehrmacht officer, one air marshal, one economic minister, one propaganda minister, the top guy in a sector. And that's why some people who probably on second thought were really deserving of being in the lead trial might not have made those lists.
Gotcha. And then at this point as well, the trial teams, well, not that they're starting at this point because they have been sort of working through trial preparation more or less the entirety of the summer. They're sifting through evidence. Documents are being flown from Germany to London and to Paris and just trying to, wherever the teams are, they're working through. And I remember some discussion, and I erroneously thought initially that all of the evidence presented in this first trial was document based, because certainly knew that it sounded like Justice Jackson and many of the others thought like, this is the strongest, like these are their words. You can't really argue with the document. You can't cross-examine a document. So you sort of just have the document. But that there were witnesses.
Oh yeah, there's a lot of witness activity in this pretrial phase. I mean, the names kind of change, but generally there's the sort of OCC headquarters team in London. There is an interrogation division headed by Colonel Amon that is also alongside a documents division. They're both based in Paris. And they're all trying to kind of get smart and share information and figure out who and what charges and what evidence we have. And then those things in different phases move to Nuremberg and become key parts of the trial preparation. So, kind of alongside each other. There are prisoners who are being interrogated, some of whom are on their way to being defendants, others whom are just witnesses. There are some non-prisoners who are being interrogated. There are huge numbers of documents that are being gathered and translated and analyzed. And then people are trying to assemble these as cases against this individual in the framework of this particular charge, et cetera. So it's a lot of moving pieces.
One thing that always boggles my mind a little bit is just the sheer manpower necessary to get all of this done when you consider the number of translators that must have been needed, the number of typists or, sort of rudimentary copy machines, whatever was available at the time.
Mimeograph.
Mimeograph. Thank you. Yes, I remember that smell from elementary school. That just the sheer numbers of things that needed to be accumulated, probably located first and then accumulated in order to even just make this function from a process standpoint also just sort of boggles my mind.
Right. In the summer, the staff is growing, and that only accelerates as we move into the fall. There are people who are recruits, and there are people who are kind of walk-ins, and there are, like advertisements for bilingual people to be interpreters, or if you're not quite that quick and that good, can you translate and be a document translator? And yes, stenographers, secretaries, quartermaster personnel, people who can kind of make supplies appear. And the Army is full of a lot of people who are in the process of being demobilized as we're moving from fighting into occupation into peacetime. So there are a lot of people on the scene, and a lot of people are needed.
Well, and let's talk about the indictment counts themselves. So there are 4 counts.
Right.
Do you want to walk through those for us first?
The London Agreement, which creates the IMT, gives it jurisdiction over 4 principal crimes. 3 are substantive crimes: the waging of aggressive war or breach of peace, the commission of war crimes, and the commission of crimes against humanity. And then the sort of inchoate crime, or the wrapper crime, is common plan or conspiracy to engage in any of those other 3 crimes. So that kind of adds up to 4. In the end, the indictment gets drafted with conspiracy or common plan as the first count, aggressive war is the second count, war crimes is the third count, and crimes against humanity is the fourth count. So those are the sort of tracks that they now need to think in, draft an indictment in, assemble evidence in, and prepare to prosecute in.
And my recollection, I think, from my reading was that each one of the allies took a certain one of those counts, although the French and Russians sort of split too. But
sort of. There's a kind of primary responsibility allocation, if you will, but there's a huge amount of overlap. The American responsibility is count 1, maybe because it was numbered 1, or maybe because the conspiracy or the common plan was the concept for this whole endeavor, that Nazism was a sort of planned multi-phase agreement to violate treaties, to break out of Versailles, to build up the military, and then to wage aggressive war and conquer the world. And that's the whole story. So the Americans have count 1. That means they've got everything. The British have count 2, which is the waging of aggressive war, sort of 1939 and forward, and the war that they responded to by defending Poland, if you will, under their treaty. But that really also spans, at least from 39 forward, everything. And then the third and fourth counts, war crimes and crimes against humanity, are ultimately a trial sort of divided up, and it begins to take shape in this pretrial phase between the French handling those activities in the West, in other words, France and its neighborhood, and the Russians handling those criminal activities in the East, the USSR and its neighborhood. But again, where's the border and what's the demarcation line? There's plenty of overlap too. And, exuberant and smart and ambitious people sometimes sort of elbow their way beyond their assigned lines.
Well, and if I remember again from research in the London Agreement, the conspiracy idea was a challenging one for the other allies. That, if I recall, and I might not be framing this exactly correctly, so please feel free to correct me, that was sort of the American concept of clearly all of this was part of a bigger plan, but that within the continental system, the conspiracy portion of it was something they weren't familiar with, they weren't terribly comfortable with. And so really, to my mind, it's not surprising that the Americans ended up taking that claim because they would have had the most comfort with it.
Yes, absolutely. I mean, the British also are comfortable and understand conspiracy. It's an Anglo concept before it's an American concept. But yes, the continental powers, France and the USSR, are variants on civil law, which doesn't have that kind of inchoate crime, greatest danger theory, which underlies conspiracy. So yeah, there's a fair amount of head scratching and maybe deferring, or maybe the Anglo-American assertion of themselves to implement their plan and charge this crime.
And it perhaps explains a little bit
The
why.
conspiracy to see this as a conspiracy.
Right. And explains perhaps a little bit of why Jackson shaped some of his trial team the way he did as well. So finding people who had been working against Murder Inc. and just sort of having that sort of background.
Right. John Amon, who I mentioned, was a Brooklyn prosecutor before he became a colonel in the U.S. Army during the war years. And in Brooklyn, he prosecuted gangland murders, New York gangs. And of course, gangs are, common plan or conspiracy paradigm cases. So Amon was a big time experienced American prosecutor. Also, Sidney Alderman, who Jackson recruited and really pretty quickly as part of the inner circle. I'm not sure how to kind of number them. Who's number 2, who's number 3 at this stage.
It's more like Dante's circle.
Right. Alderman was a civil litigator. He was the general counsel of the Southern Railroad. He argued regularly before the U.S. Supreme Court. Jackson thought he was a brilliant advocate. And part of what he did was antitrust defense, as Southern acquired other railroads and monopolized different lines and so forth. And that's also a form of this kind of common plan conspiracy talent set. And there are other people who kind of come through the Justice Department background. Thomas Dodd, who ultimately rises up to be the number 2 on the trial staff in 1946, is an experienced Department of Justice prosecutor, including racial lynching cases in the South, which are common plan and violent crime and so forth. So people have different talent sets that do plug into this concept.
And so I think one of the things that came through for me, at least in the research, is that the indictment process itself, and I'm not sure if this was shared by the American view, but at least the British thought this was moving awfully slow. Like they thought the indictments could be drafted, and again, the trial starting. I think I read in one of the pieces that they honestly thought the trial could be started and finished all within 1945 initially.
Perhaps. I mean, the British definitely had the lead pen in drafting the indictment, in part because it was happening on their turf. This was a London project, and they were all working from the at least quasi comforts of home. I don't mean to minimize how horrible, bombed out post-war London was, but they're not living out of a hotel and they're not far from home the way the other nations are. And they wanted everyone to remain in London and, kind of focus and get this done fast. Jackson wanted to be in Nuremberg and get ready for the trial and kind of refused to go back to London. He thought his London chapter was done. And he kind of grudgingly lets some of his senior people be part of this indictment drafting, but in his view, it's also taking too long because it's keeping them from trial preparation. So that kind of meanders for a few weeks in September, but is ultimately taking shape. And by mid to late September, there's a pretty full draft.
Well, you mentioned something as well that Jackson was in charge really of establishing things on the ground in Nuremberg, which none of the other prosecutors had that responsibility. So his focus really is like, okay, how's this physically going to work?
Right. Nuremberg is in the American sector of occupation. So the British, in a sense, are the host nation for the London conference, but now the Americans are going to be the host of the Nuremberg trial, which means security, facility, provisions, housing, staffing, all that kind of stuff at an international level is on the U.S. And Jackson, I don't know if it's something he thought of concretely, but he has a career of, kind of going to the place and trying the case. Whether it's Mayville, New York, or Pittsburgh, or, wherever, this is a Nuremberg trial. So, set up your trial prep and get ready in Nuremberg.
Yep.
So kind of at both of those levels, I I understand where his antsiness was about being anyplace else.
And so now that we're in mid-September, the judges have been assigned, I think by this point, both the
Not
main and the
quite.
alternates.
Yeah, the judges are a choice of each nation, and each nation is kind of moving at its own pace. The British fairly quickly identify Lawrence and Burkitt as their judges. When Jackson was back in Washington, he's consulting with Harry Truman about who the American judges are going to be. And ultimately, it's Francis Biddle, despite conflict of interest questions that need to be thought through, because Biddle, as Attorney General, had really been an architect of the plan for this back at the Yalta stage. But then Truman had fired him from the cabinet and kind of felt guilty about that, so wanted to kind of give him a job. Jackson's preferred candidate was Owen Roberts, who had just retired from the Supreme Court. And apparently Mrs. Roberts kind of put the kibosh on that. And so, who the Russian judges are going to be is kind of a mystery and a delayed issue. It's probably going to be Nikitchenko, who had been the London conference lead negotiator, but he's gone back to Moscow, and people aren't really coming back to the West from Moscow very quickly. And the French are kind of looking for somebody who's got a robe and a law degree, and it's not very important, but it's also not clear early who the French judges are going to be. So there is that sort of staffing process coming from the four nations. It then physically requires the judges to get to Berlin, which is kind of why this whole return of the indictment, convening of the IMT story slips into mid-October.
Gotcha. Okay. And so, and I feel like I read at some point too that with the indictment development going on in London, I think it was Maxwell Fyfe and was it Dementon, one of the French, fly to Nuremberg and bring the indictments with them because Jackson's in Nuremberg. And that Jackson.
It's not easy to send a PDF.
Yes, right. No email, carrier pigeon maybe, but that's about it. Jackson, I think one of the things was on the last day, he sort of handed them, here's my alternate viewing of the indictments. And then they had to go back to London with that. And so there was this exchange back and forth it reminded me a little bit of like, no, yours isn't broad enough, but yours is too broad. And let's figure out where our baby bear Goldilocks moment is.
Yeah, no, I mean, everybody's got a pen and everybody's sort of not quickly putting the cap on his pen. So there's editing and rewriting and alternative versions, and that just keeps going. And of course, that prolongs everything. One last thing about the indictment. In London, badgering the people who are the indictment drafters there, so who are the kind of collectors of all these drafts from elsewhere, is the Polish lawyer Raphael Lemkin, who had been a refugee from Poland before the Nazi invasion and had become a professor and then a War Department consultant and kind of floating around in the US and mostly in Washington, D.C., and publishes through the Carnegie Endowment a collection of all the Nazi decrees in 1944 and coins this term genocide, which he says is necessary because there is no existing word in humanities vocabulary that captures the kind of common plan or design to exterminate a religious, racial, or ethnic group. And that's what Nazism really is. So he takes geno, genus, population, and side, as in homicide, suicide, and puts them together and comes up with genocide, genocide. And that's his word, and that's in his book in 44. And he's exuberantly distributing his book everywhere. And pushing his theory everywhere. He's in Robert Jackson's office in May of 1945, as soon as Jackson's assigned to this job, to sort of volunteer to be part of the project and to push his word and his concept. And then he's in London before the agreement in the summer, kind of on the margins as a consultant, meeting with people, talking, etc. And now in September, he's really working the drafters to get his word in the indictment. And the British reaction, which I love, it's just a classically stereotypical British moment, is it's not in the Oxford English Dictionary, thus it is not a word. And Lemkin just won't take no for an answer. And I think he's both brilliant and kind of possessed. and just keeps badgering them. And eventually he gets his word in the indictment. So the Nuremberg indictment, drafted in London in September and ultimately publicly filed in Berlin in October, contains the word genocide. It's the first official governmental document, and it's a four-nation international indictment that uses the word genocide. But it's tucked into a weird place. As we kind of understand genocide, with 75 years and unfortunately lots of context to understand it, it's a cousin, or it kind of grows out of the category of crimes against humanity. In the Nuremberg indictment, it's in count 3. It's in the war crimes charges. And it basically is just kind of tacked into a long run-on sentence about what the Nazis did in the conquered and occupied lands. Murder, expropriation, subjugation, torture, etc., genocide. And you can just almost picture somebody, with a pen, drawing a little, carrot and a little balloon and adding the word in here because we're going to put the word in. Will you now go away? So the word is there. And of course, historically, that's important.
Very, yes. All right. So now we're early October.
Right.
I think the prosecutors have largely agreed. The indictments are set, but then there's still a delay for, copies to be made, it to be translated into all the languages it needs to be in for the judges to actually get to Berlin. Why don't we?
Going to Berlin is itself an argued issue and a bit of a compromise.
Well, remind us why we're in Berlin.
Right. Nuremberg is the selected site for the first, which turns out to be the only international trial, and that's in the American sector. To be fair, above all others, the nation that won World War II in the European theater was the USSR. They lost tens of millions of lives. They defeated the Nazis at the gates of Moscow and Stalingrad and so forth. And Berlin is in the Soviet sector of occupation. And they want this to be on their turf. This is the accountability process for the arch criminals of fascism. And they did it to us, the Russians, more than anybody else. So, by God is probably not the word they're using. This should happen in Berlin, our sector, etc. Berlin is a sort of four-nation allied city within the Soviet sector. And so the compromise is that the convening of the IMT, its first official meeting, will occur in Berlin. The judges will go there, they'll be seated for the first time, and the indictment will be publicly filed by the prosecutors to them in Berlin. And then they will all repair to Nuremberg for the first trial, starting more or less 30 days later. And then in the future, we'll see where a second trial occurs and additional trials. Robert Jackson thinks that this is all just more delay, and is kind of impatient with the idea of a ceremonial gathering in Berlin, particularly if it has to take a lot of time out of his trial preparation. So he's, I think, understands where the Soviets are coming from, but pretty hard negotiating against them not to get Berlin. Eventually, he and all compromise, but let's do it fast. Let's touch the base in Berlin and keep moving, is the Jackson attitude. And it takes a while to even get to Berlin. We're waiting for indictment, translation. We're waiting for judges. We're waiting for prosecutors. We're, doing all of those things. And so kind of readiness that could have been in late September is now slipping into early October and then into mid-October. And ultimately, the event doesn't happen until October 18th.
And then at the same time that the indictments are read and officially or official, they also announced that the trial will start on November 20th. So at this point too, as you said, we're about 30 days from this massive trial that's about to get underway.
Well, the London Agreement provides that the defendants have the right to be served with the indictment in writing, and then 30 days to work with counsel of choice and have access to documents to prepare their own defense before the trial will start. So the 30 days is sort of baked into the agreement and the plan, and it's going to be triggered by when we finally have the opening ceremony in Berlin. So October 18th, becomes November 20th trial start.
Although I feel like I also read somewhere that at least some of the judges were a little surprised that the defendants hadn't already had counsel. So, they were thinking, look, they've been in jail for a number of months at this point. I think they were served, I think the defendants themselves were served the next day on the 19th, if I'm remembering correctly.
The 20th, I think.
On the 20th, okay. And then at the same time, they were provided a list of potential defense lawyers that they could choose from. And they were, I think some of them were really concerned about, who is going to defend me? How are we going to find people? How vigorous is this actually going to be? Are there going to be blockages to me getting a defense attorney, intentional or otherwise? It felt like at that point, like it really became real to them, and they were thinking, not prepared for this.
Yeah, no, I think that's right. I mean, obviously they're prisoners and they don't have assets, and they're spiritually broken probably by the defeat of this system that they were a part of. And they're not sure that the Allies are really, going to do this, as opposed to taking them out and shooting them, or, kind of more time happens and slips past and then maybe they forget about it. Who knows if they're really focused, but none of them have a sort of lawyer at the ready. So they have to gear up and do that starting when they get the indictment on October 20th.
And then you mentioned Martin Bormann earlier as well. And because they didn't know if he was still alive or where he might be, they went through some extra special steps to make sure they were doing whatever they could to really make that notice out in the, I think it was like a couple 100,000 copies of the indictment were distributed, and it was broadcast on the radio and published in the newspapers. And I feel like there were posters put up, sort of like, really, there's no way, should he be discovered later, he could say, I didn't know this was happening.
If trial in absentia is a fair process at all, they were bending over backwards to, kind of give him notice, show up, you're being prosecuted. They have an attorney defending the ghost of Bormann, all that kind of stuff. I think it shows that they thought there was at least, or some of them thought there was at least a serious chance he was alive.
Yeah. Well, I think most of the world thought that until a couple of years ago when they discovered his remains under a wall in I think it was in Berlin.
Yeah.
So, all right. We are going to open it up to some questions. And one of the first questions, and I'm going to just actually take these a little bit out of order because I think this makes sense to tackle it this way, is we discussed why the initial step was in Berlin. We do have a question from Noah as to why Nuremberg was chosen as the city for the trials, given it was so damaged. What made Jackson and the team think Nuremberg would be the best location for that?
Well, it was the recommendation of the U.S. Army as a site within the American sector where they could secure this. The U.S. Army didn't sort of trust anything in the British, French, or Russian sectors. And although center city Nuremberg was badly damaged, in fact, kind of on the outskirts of the old city, Nuremberg had a large courthouse prison complex that was damaged, but could be repaired and became the trial site. So the U.S. Army on the ground kind of scouted that all out and recommended Nuremberg. And then Jackson took the British and the French to check it out in July. It was before the Soviets had really kind of come aboard, but belatedly they came aboard, especially once they got the compromise of the opening event in Berlin, that Nuremberg was physically suitable. Once Nuremberg is kind of picked for those security reasons, it does have the kind of cosmic historical associations with Nazism that kind of add something. The Nuremberg rallies and the Nuremberg laws of the 1930s, Nuremberg being a spiritual home of Nazism, makes it extra appropriate that it's the place where Nazis will be prosecuted for their international crimes. But that's really not the reason it was picked. That's sort of a salutary benefit of the Army believing it was a place that was a good site.
Gotcha. Okay. And we have a question from Peter. How was it possible to convince the Russian officers to create new laws? The USSR had a fairly decrepit legal system, as bad or worse than that of the Nazi state. Any thoughts on that?
I don't claim to have any expertise in, Soviet legal history or Russian legal history or you name it. The negotiation in the summer of 1945 is a continuation of the alliance that had fought and won the war together. And so they have gotten the unconditional surrender of the Nazis. They have occupied the land that had been Germany. There is no Germany anymore in this moment. It's Allied occupied former Germany. And they decide to stay together as an alliance to hold accountable these arch criminals. That is a political decision, no question about it, by all three of the great powers and France as the sort of smaller brother joining them. And I think from that political decision flows whatever legal flexibility or innovation is required to wrap their minds around conspiracy or to defer to the British and the Americans taking the lead on conspiracy. I think it's legal development through politics, which is, of course, where laws come from.
Absolutely. All right. If you have other questions, please put them into the chat on Facebook or email us and we will answer them. But John, in addition to the indictments, now with the judges in place, they actually sort of have a fair amount of control. Like there's work that they need to be doing as well, if I'm recalling. So they actually sort of, I don't know if it's spearhead, because I know some of this work was being done by Jackson and his team, but they're looking at the physical arrangement of the courtroom. I think they were also responsible for at least figuring out what the security measures were going to be for the prisoners and the witnesses. So it wasn't as if the judges just showed up and.
No, that's right. And they have to constitute themselves as a court. Under the London Agreement, it's a 4-judge court with 4 alternates. Now 8 people finally assemble in Berlin and they're meeting each other. And they're starting to figure out how we're going to function as a court. They pretty quickly figure out the sort of making 4 guys wait in the back room in case one of us dies doesn't make any sense. So they immediately begin to function as a court of 8. There are 4 principals who I guess are formally the voting judges, but all of the proceedings thereafter, all of the discussion thereafter, etc., is a court of 8. They have to figure out, what its leadership is going to be. Who will the president of this court be? Francis Biddle very much wants to be the president of the court. And Jackson basically tells him that would make it too much of an American show. Let's let Lord Lawrence, Geoffrey Lawrence, the British judge, be the the president of the tribunal. They need the apparatus that a court has, a clerk, a secretariat, a paper flow system, all the stuff that makes a court. And they are beginning to figure that out a little bit in Berlin as they meet each other and have their preliminary planning conversations. And then as they repair to Nuremberg, they have to get set up in housing and they need office space and they need judicial assistants and staff and so forth. And they need to check out the courtroom and they need to, kind of kick the tires and make sure the lights work and the microphones work. And, sort of all of that stuff of getting to the starting line isn't just for prosecutors. It's for defense attorneys, as we've touched on, and it is also very much for the judges.
Well, and not to mention just also I have to imagine, because this is something we still discuss, like what access will press have? How are you going to allow things to be recorded? Just sort of all those things that we are fairly standard for us now, but I have to imagine for them balancing the idea of we want this to be as public and open as possible, but also preserving any privileges or any sensitivities about having some of this information, which would have been fairly graphic, broadcast out to the world.
Yeah, and security. I mean, also the kind of concerns about Nazis in the woods aren't just prosecutor concerns, they are judicial concerns. And along the way, obviously they all survive, but there are lots of people who die along the way. There are, American soldiers who are killed regularly during the trial by, crimes in Nuremberg. So securing the judges is another part of this project.
And I wanted to back, since Justice Jackson took a 15-month leave of absence to oversee this whole process. And I know we're
not
only
not actually a leave of absence. He never
Okay.
took a leave of absence. He just stopped showing up.
Oh, okay, got it. All right, so
Taking
not
a
an
leave of
official. Hey,
absence-
I'm going to be away for a bit.
Right. Taking a leave of absence means asking your boss if you can be released. And Jackson had no boss. He was a Supreme Court justice. And so he had a summer recess, and he had the president of the United States ask him to do a job. And he just said yes. And that becomes increasingly controversial as it takes time. And it is rubbing some of his colleagues the wrong way and others not. There's some jealousy, why him, not me. But there's also the kind of, 8 of us are doing the work of 9. Why is he off on a holiday? In a caricature, at least.
Yes.
So yes, Jackson is full-time on this job, away from his other job.
Well, and just given the timing of this, so as we're early October, mid-October, the 45 term has just started for the court. And so I have to imagine that was probably also fairly top of mind for him, that court has resumed its session.
He's in a hurry. He knows he's missing the court and that it's shorthanded and that there's grumbling and so forth. He's trying to get home, his wife, his life, his future, it's all American. He had offered to resign repeatedly to Harry Truman. He said, you want me to do this job, I will do this job, but we shouldn't, sort of stiff the Supreme Court. You can have the Supreme Court seat and get somebody else to do that job. And Truman repeatedly says, no, I don't want you to resign. I want you to be back on the court when this is done. So I want you to sort of skip out on that job, but have it to go back to. And they had just been discussing that in their meetings in September before Jackson's return to Europe, to Nuremberg, and so forth.
Okay. All right. We have a question from Ryan. So in the eyes of the prosecutors, were the outcomes ever thought of as a foregone conclusion?
Nobody prosecutes someone they believe is innocent. Nobody decent prosecutes somebody who they don't believe they can carry their burden of proof and show the guilt of. And the evidence against these defendants was overwhelming in almost every case. In the end, at the end of the trial, 3 of the 21 humans in the box were acquitted. And, to the prosecutors, that stung, I think, including Jackson. But, kind of on reflection, I think he was really quite comfortable with that, and it showed the independence of the tribunal. Also, at least one of them was a fairly thin case, the case against Hans Fritzsche, who the Russians had insisted on being a defendant and kind of a stand-in for Joseph Goebbels as a propagandist. And Fritzsche was not very much an arch criminal. He was a bad guy and a criminal, and ultimately he was convicted in German national courts and served some time. But that acquittal might not have stung very much.
Well, and certainly the way we frame it on the tour of the Jackson Center as well is that although they would have hoped that all 22 would have been found guilty, it was, as you said, really a vindication of, we set this up correctly. People understood the burdens of proof. The judges did not feel we met the burdens of proof for these 3 individuals and rightly ruled that they were not guilty. So that, while it may have stung, sort of vindicated the process itself, that it had been established in a fair way.
Yeah, I mean, conviction or acquittal is a judicial task. So in the end, the prosecutor, sort of makes his arguments, presents his evidence, and then it's up to the judges.
We have a question from Daryl going back to what was happening in the US at this time. He wondered, was the Supreme Court split like it is today? And so was Justice Jackson worried about 4-4 deadlock, or that some cases would go, I guess, the wrong way without his voice?
Yes, the Supreme Court in this time period was quite divided. Generally, yes, it was a kind of 4-4 court without Jackson. He was not at all concerned about outcomes going the wrong way. Kind of one of the things that cuts across all his judging is he never thought a judge should be either praised or criticized for an outcome. You just decide the case, and every judge comes out where the judge comes out, and then on to the next case. So you don't, kind of give awards to heroic judges for good decisions, or you don't blast horrible judges for bad decisions. Judging, a corrupt judge, that would be a different thing. But, in general, a judge doing a judge's job has cleared this case, done his best, goes on to the next case, and so forth. So, 8 of them could do their judging. Yes, that meant a lot of 4-4s. There were 22 cases in that 44 term that were 4-4s, and most of them were put over for re-argument the next year when Jackson was back. So, he kind of knew that his workload was piling up in Washington and in this extra way. But he had a job to do in the short term, and that was in Nuremberg.
Absolutely. So then in the 30 or so days between the indictments and when the trial actually starts, what is left to do? I mean, obviously, we're still preparing the trial. We're still
before we go to that, let's talk a little bit more about Berlin, just mechanically. And then if you want to put up some of the images, let's do that.
Yeah, absolutely.
What they do in Berlin is wait around, and Jackson gets sick of waiting around. He's been there since October 6th, which is a Saturday. He's there for 4 days, and he's meeting with lawyers and allied counterparts and doing work and so forth. But most of what he wants to be doing is in Nuremberg. So he's not going to wait around for Russian judges and American judges anymore. He leaves a couple of his deputies to remain in Berlin to handle this opening ceremony whenever it occurs, which ultimately doesn't occur to October 18th. It occurs in a building that's being used by the Allied Control Council, which is a regional court in southwestern Berlin, in Schöneberg, called the Kammergericht. It's a building that was largely intact in a courthouse, and it had been notoriously a site of the Nazis' people's courts during the war years, including the building, literally the room, where Roland Freisler, the Nazi judge, had presided over the sort of hanging trials of the July 20th, 1944 plotters who had tried unsuccessfully to assassinate Hitler. And there are films, you can find them on YouTube, of Freisler, screaming demonically at these defendants. Not much of a judicial temperament, but a really awful Nazi. Freisler was killed in an Allied bombing. A piece of a ceiling crushed his head. And so he was not alive, but this is Freisler's courtroom that now in October 1945 is being used by the Allies to begin the process of holding the Nazis accountable. That's a piece of karma or historical echo that's quite interesting.
Absolutely.
The British chief prosecutor, Hartley Shawcross, who is also the attorney general in the newly elected government, flies over and is the presiding chief prosecutor who's present in this Berlin ceremony event, which is the presentation of the indictment to the court. He's the only one of the 4 chief prosecutors who ultimately are in Nuremberg for the trial, who's there for Berlin. And ironically, he's not very much in Nuremberg. He's kind of in and out, but mostly he's in London because he's the Attorney General of the UK. Whereas his predecessor in that job in the war government, but Conservative Party member David Maxwell Fyfe, who's his deputy in Nuremberg, is the person who's there kind of day by day and functioning as the lead British trial prosecutor, if not the chief prosecutor. And there's a Russian kind of stand-in, Roman Rudenko, who ends up being the chief Soviet prosecutor, is not yet assigned and has not arrived in Berlin to be part of this proceeding. And it's all over, pretty quickly. There's the side meetings and all the judicial get acquainted and go to work stuff. But the October 18th proceeding is not a prolonged thing. It's not a full reading of the indictment that happens on the first day of the trial, and it's soporific to read this long document.
I would say it was like 65 pages or something along that line.
Yeah. I mean, the judges didn't need to do that twice. This is merely the handing up of the indictment, and the prosecutors attesting that they will be serving it on the prisoners who are named herein in Nuremberg tomorrow and Saturday, etc. And then basically after that, the judges disperse. Francis Biddle has an American plane, and he gives a ride to the French judges to Nuremberg. The Brits go home. They go back to England. Like they're postponing Nuremberg a little bit longer. And the Russians kind of make their own way to Nuremberg. I'm not as clear on how direct or delayed their arrival is. So it's an interesting, brief ceremonial meeting, but it is the convening of the IMT in this historically echoing place.
Well, and also perhaps a reason why Justice Jackson didn't necessarily see benefit in sticking around when he could be doing actual trial prep, because I don't know how short it was, but it was basically, you're taking these oaths, we know that they're indictments, and you're going to serve them on the prisoners in the next day or so. So
yes, exactly. There was not a lot that required his presence, and there was a lot that he could be doing in Nuremberg, trial preparation teams, preparation of trial briefs, writing his opening statement, all that kind of stuff was very much on his front burner. So this is Jackson posing for a publicity photo on May 1st, which was the day before Truman unveiled him. And this is Jackson at the Supreme Court getting ready to ditch the Supreme Court. And as far as I know, he never even asked permission to sort of do the photo shoot, much less to go to Nuremberg. This is the London conference, and it just shows the four-sided table with the British facing us and the Russians have their back to us. The French are on the left and the Americans are on the right. That's Jackson in the bow tie, Wild Bill Donovan behind him, white hair in front of him is Murray Bernays, and on the front corner is Jackson's son, Bill Jackson, who is his executive assistant. Nice. And Jackson's secretary, Elsie Douglas, is behind him. She's taking incredible stenographic notes of the London conference. That's how we know what happened in all these sessions.
Yep.
This is the scouting trip, July 21, 1945, to check out Nuremberg. And so it's Jackson, fourth from the right, kind of with his right leg extended a little bit, taking his British and French colleagues on his plane, his C-47, to check out the city of Nuremberg, which means lunch at the Grand Hotel, which is still kind of dilapidated and being rebuilt and covered with scaffolding. And then they inspect the Opera House as one possible trial site. And Jackson and David Maxwell Fyfe next to him in the tan suit both say, no, we're not having a trial in an opera house. And then they inspect the Palace of Justice. What's interesting, I just want to go over to the left side, is that you kind of get a sense of who Jackson's inner circle is. On the far left, that's Sidney Alderman, who I mentioned. Mm-hmm. Next to him is Francis Shea, who was originally a Jackson friend from Western New York. He was the dean of the University of Buffalo Law School. Jackson recruited him to the Justice Department, and he ran the Civil Division, and now he's part of this project. And then in the middle, right in front of the doorway in a kind of white sweater vest, is Gordon Dean, who had been a very important Justice Department lawyer, Supreme Court advocate, trusted right-hand guy, and also sort of the public affairs officer at DOJ in the late 30s and when Jackson was AG in 40 and 41. Those three people are a lot of the inner circle, and we're going to see at least two of them in Berlin.
Gotcha.
This is the signing of the London Agreement, and Robert Falco is the glasses on the right, French chief negotiator, and this is the Lord Chancellor of Great Britain on the left, William Jowett, who is a ceremonial signatory on behalf of the UK, had not been kind of in the room doing the heavy lifting of the negotiating. This is Jackson and Gordon Dean, guy who was wearing the white sweater vest. Yep. Now they're in Nuremberg. I think this is September. It's a little hard to kind of date some of these photos, but from the light and the warm weather and, kind of in the scheme of things, Gordon Dean then developed some health problems. You can kind of figure it out by his, unfortunately, short stay in Nuremberg. And of course, it's wreckage behind them. I think this is the building across the street from the Grand Hotel. I'm sorry, from the Palace of Justice. So this is them outside the courthouse posing a little bit or looking at the courthouse, and it's a couple of weeks before Berlin. So this is geography. In the center bottom, you see Nuremberg, And in the top right, you see Berlin. They weren't adjacent to each other. So it is a trip. You've got to make your choice if you're going to be working in Berlin or if you're going to be working in Nuremberg. Next slide. This shows how Germany, the former Germany, was divided into Allied occupation zones. So the black spot in the pink on the top is Berlin. That pink area is the Soviet sector of occupation. The yellow sector to the left is the British sector of occupation. The blue center bottom and Nuremberg kind of in the center of the blue is the American sector of occupation. And the red, white, and blue stripes is the French sector of occupation. So you kind of get a sense of, Nuremberg being in the greater United States, if you will, in this moment, and Berlin being in the greater USSR. This is Berlin, and the red zone, the dark red zone is Schöneberg, the neighborhood where the building is, the Kammergericht. To the lower left of there, you can see a neighborhood called Dahlem, and that is where Jackson was staying during his kind of fidgety 4 days there. Mm-hmm. The General Clay U.S. command of the Allied occupation was headquartered in Dahlem. Jackson is staying with Charles Fay, who had been Solicitor General, the number 2 man in the Justice Department during the war, and was a close Jackson friend, and now is the principal legal advisor to General Clay. So, this Nuremberg project is part of military occupation, and in a sense is under General Clay and his lawyer. And so this is who Jackson is hanging with. The area just a little bit above Dahlem, I think it's called Zerndorf. I'm not sure about that. Is where the British lodging and headquarters was. And Jackson is spending a lot of this 4-day period traipsing back and forth between a meeting here and a dinner there and a meeting here and a dinner there. And he was not viewing this as a good use of his time. So this is just text off a German museum display that explains the Berlin Superior Court building that the Allied Control Council is using on October 18th, and how it had previously been the People's Court, where Roland Freisler had sentenced the plotters against Hitler, etc., and the 4 counts. So it sort of shows the arc of Nazis have lost the war, Nazis are in the dock, Nazis are being held accountable. Go the next one. That is the Kammergericht, that is the building. And the arched windows on the 2nd floor, as we would call it, are the room where this October 18th event occurred. Another piece of text, its official name, Superior Court of Justice, Berlin, Schöneberg, in circa 1930 and forward had been a people's court. Can't quite be 1930, but in the 30s. It's convened there under General Nikitchenko because we are, of course, in the Soviet sector. So now this is the judges in that room. This is the only photo I've ever seen of the judges in this proceeding. Nikitchenko is the man in the center. To the left of him with the bald pate is Francis Biddle. And to the left of him is John Parker, the Chief Judge of the U.S. Court of Appeals for the 4th Circuit. Those are the 2 American judges. And I'm sorry, Nikitchenko is the 4th from the right. The center man is his alternate, Alexander Volchkov. And the far right is one of the French judges, Donadieu Devab, with a dramatic mustache. So what's cropped out of the picture is both British judges and the French alternate. They were there, but nobody snapped a picture, at least not that I've ever seen. This is from the judge's view, if you will, and you can see the windows now. And this is the prosecutors. And again, it's a partial cast, but from the left, that's Francis Shea, head of the DOJ Claims Division and former University of Buffalo law dean. And next to him is Gordon Dean. So now we've seen Gordon Dean in 3 photos. Those are the 2 people who Jackson left in charge in Berlin to handle the representation of the U.S. for this proceeding. The center figure is a young British MP, Elwyn Jones. He was a Welsh barrister. He had been a soldier. He had just been elected in that summer 1945 election, and he is sort of seconding the man who's standing, and that's Attorney General Hartley Shawcross. The furthest to the right is the Soviet representative, and that is not somebody who goes on to play an important role at Nuremberg. And this is the Kammergericht today. It is again a German national court, a regional court. It's a beautiful building. It's beautifully maintained. As you can see, it's got a great lawn and some kids playing football on it. And it's, you know, a courthouse, much like the Palace of Justice in Nuremberg is a courthouse. It does have some signage that explains the kind of People's Court Nazi history and then the IMT meeting. It's been a few years, but in my contacts with judges there, they are very aware of the history and kind of legacy of the building, and they're quite proud of it.
Nice. Okay. Thank you for the field trip as well. That was great. Okay, so we are just about at the hour mark, and so I'm going to wrap us up. I'd like to thank our audience for joining us for tea today. Please join us next Wednesday afternoon at 4 p.m. Eastern for a special conversation on the Electoral College with Professor Edward Foley. Professor Foley holds the Ebersold Chair in Constitutional Law at The Ohio State University, where he also directs its election law program. And we'll be looking at how the Electoral College is supposed to work and what modifications to the system might be possible, are possible. And if you'd like to do some reading ahead of time, that was excellent, John. I would suggest his book called Presidential Elections and the Majority Rule. It was published this past January. And Professor Barrett will also be joining us to highlight Justice Jackson's thoughts on the Electoral College, which are showcased in one of his dissenting opinions, Ray versus Blair. This is a free webinar, but it does require registration. So please go to the Jackson Center website, roberthjackson.org, to register. And again, that's next Wednesday at 4 p.m. Also, another reminder, since I've been doing this for each of the T's, Election Day is 19 days away. Please vote. John, thank you so much for being with us today. I really appreciate this walk down history.
Thanks, Kristan. It's been fun, and I'll see you next week.
Sounds good. Thanks, everyone.